A landmark case on domestic violence. Prabha Tyagi vs. Kamlesh Devi. A detailed overview of the legal proceedings. This presentation outlines the key details of a domestic violence case involving a woman seeking relief under the Domestic Violence Act, 2005, against her in-laws. The daughter-in-law's right to reside in the shared household was held to be intact due to her ongoing domestic relationship and status as a daughter-in-law, even after her husband's tragic death in a car accident. Prabha married Kuldeep Tyagi on 18 June 2005, following Hindu rites in Haridwar in the state of Uttarakhand. Dowry and Stridhan, gifts for the bride, were given by the bride's family to the husband's family during the wedding. Initially, the woman lived in her husband's ancestral home with her mother-in-law, brothers-in-law, and sisters-in-law. Later, she moved to village Jhabreda with her husband and in-laws. Kuldeep Tyagi passed away on 15 July 2005 in a car accident. After the funeral, Prabha was forced to move to her father's home in Delhi. Prabha gave birth to a daughter on 30 March 2006. Due to ill treatment and harassment by her in-laws, she relocated to Dehradun, Uttarakhand, and started working as a teacher to support herself and her child. The Stridhan given to her during the wedding was never handed over to her and continued to be used by her in-laws. Prabha sent a legal notice dated 22 November 2006, requesting them to return the articles of Stridhan. However, there was no response to the same.
The Special Judicial Magistrate at Dehradun delivered the following judgment on 12 May 2011. The in-laws were ordered to pay 10,000 rupees as compensation for insulting the aggrieved person. The court directed that the Stridhan, dowry, items listed in the application, except the Maruti Alto car, should be provided to the aggrieved person at her Dehradun residence. The in-laws were instructed not to obstruct the aggrieved person or her daughter from accessing or enjoying the property of her late husband, Kuldeep Tyagi.
The mother-in-law filed Criminal Appeal number 53 of 2011 before the Additional Sessions Judge, Dehradun. On 11 July 2014, the First Appellate Court overturned the trial court's judgment from 12 May 2011.
The First Appellate Court held that Prabha had lived in Roorkee with her husband and not in the shared household in Jhabreda with the in-laws. She only travelled to Jhabreda for work. Since she did not live in Jhabreda, her Stridhana was never in the possession of the respondents, so there was no question of them using or disturbing it. No evidence was presented showing that Prabha lived with the in-laws after her husband's death, thus no domestic violence claim could be established. Prabha was not entitled to a residence order until the property, co-owned by her late husband and the in-laws, was legally partitioned and she received her share.
Dissatisfied with the First Appellate Court's ruling, Prabha filed a criminal revision petition with the High Court of Uttarakhand in Dehradun.
The High Court held that a protection officer must file a domestic incident report with the magistrate under Section 12(1) of the Devi Act. Prabha submitted only an application alleging domestic violence, without the required report, failing to comply with the Act's requirements. To establish violence under the Devi Act, a domestic relationship and shared household must exist. Since Prabha had been living separately from the respondents since her marriage, there was no domestic relationship, and thus, no relief could be granted. It was not credible that all articles of Stridhan bought in Roorkee were delivered to the in-laws in Jhabreda.
Prabha appealed to the Supreme Court.
The Supreme Court ruled that Section 12 of the Domestic Violence Act does not require a magistrate to consider a domestic incident report before issuing orders. A magistrate can issue ex parte, interim, or final orders without this report.
The Supreme Court further held that it is not mandatory for the aggrieved person to reside with those accused of domestic violence at the time of the incident. Women related by blood, marriage, or adoption can seek relief under the Devi Act, including the right to reside in a shared household. A subsisting domestic relationship is necessary for claims of domestic violence. However, the relationship does not have to be ongoing at the time of filing the application. An aggrieved person who has previously lived with the respondent or has the right to do so can file an application under Section 12 of the Devi Act, even if they are no longer in a domestic relationship at the time of filing. Finally, the Supreme Court held that the High Court of Uttarakhand's judgment of 23 July 2019 in Criminal Revision number 186 of 2014 is set aside. The Additional Sessions Judge's judgment of 11 July 2014 in Criminal Appeal number 53 of 2011 is also set aside. The order of the Special Judicial Magistrate in Miscellaneous Case number 78 of 2007, Dehradun, is affirmed.
This case highlights important aspects of the Domestic Violence Act, including the rights of women to seek relief and shelter even in the absence of a domestic incident report, and the ability to claim relief and the right to residence in the shared household. Thanks for watching.